Good afternoon, and welcome to part 3 of our OGE Form 450 series. I'm Patrick Shepard, and very happy to be joined today by Cheryl Kane-Piasecki.
Twice in 1 week, Patrick. How about it?
Yeah, I know why we don't do this twice in 1 week very often.
You don't enjoy my company? Is that what you're trying to suggest?
No, that's not it at all. So welcome back to part 3 of our review of the OGE Form 450. Today we're actually going to get into the form and look at some entries that you might see and juxtapose those with some of the tools available to help you in the review process. But the first thing we're going to do today is talk about the review process in general, both why we do it, who does it, why that is, because we think that's a really important basis for understanding your role as a reviewer, be that as an intermediate reviewer, as a line reviewer in your agency, or as the final certifying official. So I'm going to take a quick look at a section from the guide. That discusses the review procedures. And so this is from section 3 of the guide. And basically there are 3 steps to the review process, which is good because that's about as many steps as I can remember at once. And the first step is a technical review. And by technical review, we mean making sure that you have the information on the form that you need to have on the form. And the question I like to ask when it comes to the technical completeness of a form is, do I have sufficient information to make a determination definitively one way or the other that this asset or reported entry is likely to pose a potential for conflict of interest?
Absolutely, because as we've said repeatedly, and as the guide actually itself is going to suggest to you in various sections of this section 3 of the guide, the purpose of confidential financial disclosure is to disclose and remediate potential conflicts of interest. So the information that's on the report is not disclosure for the sake of disclosure.
Right.
Now, we want these to be materially sufficient, but that's not the same thing as saying they have to be technically perfect. So the goal of our review and the goal of this entire system is to prevent conflicts of interest. So we just want to make sure we have sufficient information to be able to know what it is we're looking at so that we can actually perform that analysis.
Exactly. And you can see here in the guide, when we discuss technical review, that second bullet is really the important one. Determine whether the entries provide sufficient information to complete a conflicts analysis. So the technical reporting is subordinate to the conflicts of interest analysis. It's a tool that helps us get to the conflicts of interest analysis, which is our second step. Once we have the information that we need to make a determination one way or another about a conflicts analysis, we need to look at that entry and decide, does this pose a potential for conflict? Is there a nexus between the duties of the position that the filer occupies and the holding or entry that they've reported on the 450? And the reason we need to do that is because the certification statement that we're going to attest to says that we certify that the filer is in compliance with all applicable laws and regulations. And in order to do that, we have to determine that they are, in fact, in compliance with all applicable laws and regulations. And by that, we mean the conflict of interest statutes and the standards of conduct.
And that's an important point, too, is to emphasize that while 18 U.S.C. Section 208, the conflict of interest law, is one of the primary things that we're doing this review for, in addition to the impartiality provisions of the standards of conduct, you do have to have some degree of familiarity with the entire body of law and regulation in order to be able to spot other types of potential conflicts of interest or issues that could implicate one of the other criminal statutes or another part of the standards of conduct.
No, absolutely. So once we've found the potential for conflict of interest or the absence thereof, if we find that there is a potential for conflict of interest, we have to do something.
Right.
And this is perhaps the most important part of the review procedure. This is what we're trying to get to. This is the whole purpose of the exercise, is to implement remedies, to make sure that our employees do not engage in conduct that would constitute a financial conflict of interest. And the way we do that, we'll talk about at the end of this exercise, but it means we need to take steps either through advice or steps like selling assets or resigning from outside positions to make sure that there isn't a possibility for conflict of interest. And only once we've taken those steps, only once we've taken care of the risk for potential conflict, may we certify the report.
Mm-hmm.
So the next question is, who certifies the report? And this is another area where OG's regulations give agencies a lot of flexibility to design programs that are sufficient to the needs of your organization. We recognize that some agencies have a handful of employees, maybe 3 or 4 filers, maybe a dozen filers, and some of you have hundreds, maybe thousands of confidential financial disclosure filers. So deciding that one official is the only person who can certify a report just doesn't make sense. It wouldn't be practicable. So who might be able to certify a report? Well, of course, the designated agency ethics official or the alternate. So if you're the DAO or the ADAO, you can certify reports. Or anyone to whom the DAO has delegated the authority to do the same. So if the DAO says, I think supervisors should be certifying authorities, I think deputy ethics counselor should be supervising authorities, if that person is designated as a certification official by the DAO, they may certify reports. We do have a note here that only the DAO or a DAO, in case there isn't a DAO, can certify the reports of presidential appointments requiring Senate confirmation. But otherwise, for your line 450 filers, the DAO, the ADAO, or anyone designated by the DAO or ADAO.
The only thing that I would submit in with respect to this is absolutely agencies. You have the authority to delegate these authorities to whomever you think is where it's most practicable. But however, you do have an obligation to make sure that whoever your certifying officials are sufficiently trained in the conflict of interest laws and standards of conduct so that they actually can perform that function.
Right.
So there is, I think, a knowledge requirement that you really are on the hook to make sure that your folks are adequately trained up to, if you're going to give them that authority and that responsibility.
Right. And in fact, OG has codified that responsibility of the DAO in 5 CFR 2638. The DAO has a duty to make sure that people performing ethics functions are sufficiently trained, that they are capable of performing those functions. We'd of course encourage you to use our tools. The Institute for Ethics in Government is designed to help agencies make sure their folks are trained. So if you want to assign your subordinates our classes to get them up to speed in order to review and certify 450s, that's why we do these things.
Precisely.
But it is important, as Cheryl mentions, that we make sure that they are capable of doing the work, because ultimately that's the result we're looking for.
Mm-hmm.
So we also indicate one of the challenges, I think, with 450 filing is knowing what it is that our employees are working on, what they do at work. If you're at a large agency where you have hundreds of employees or thousands of employees, it's very difficult to find out what each of those individuals is likely to do over the next year. Mm-hmm. That's just a huge amount of information that we would have to onboard as centralized reviewers in order to conduct meaningful conflicts analyses. So we do have a provision that allows for intermediate reviewers. This is not compulsory. If you're at a small agency, you know what everyone does. You can review those reports for potential conflict because you have all the knowledge you need. Don't have to do intermediate reviews. It's completely optional. But if you find that that's a necessity for your program, we do have a provision that allows us. And in some cases, agencies have supervisors work as intermediate reviewers to help them flag in sort of broad contours the possibility of conflict and where they find that to work with the certifying official to remedy those conflicts. I think that can be a good way to do things. We typically offer a training course for intermediate reviewers in January. Mm-hmm. We will likely do so again this year. There's one available on the Institute for Ethics in Government site right now. So if you do this, there are some tools to support you. And this can be a good way to get that second piece of information, which is what are these people working on, so that you can compare that with their financial holdings to identify the potential for conflict. So the next thing we want to talk about is, when do you need to go back for more information? And I think this is a sort of critical question for new reviewers particularly. And I think a lot of the skill in reviewing confidential financial disclosure reports or any financial disclosure reports is seeing what information isn't there that ought to be or that you need in order to make a determination about whether there's a potential for conflict. So we have a long discussion of this in the guide, which you can take a look at. But to summarize it, where we really need to get to is to be able to determine for each entry that's included on an OGE Form 450 that either, one, it will not pose a potential for conflict for this employee, or it potentially does pose a conflict of interest for this employee, and we have steps that we can take to mitigate that. We have to get to one of those two determinations. Either there's potential for conflict and we can remedy it, or there's not going to be a potential for conflict based on this entry. And if you don't have sufficient information to come to one of those two conclusions, you need more information.
Absolutely. And I think additionally, this is where reading the form as a story,
Right.
where each of the parts gives you a different piece of information to help you pull together what this story, the complete story, is another area where once you get accustomed to reading, for example, between part 1 and part 3, outside positions, where you look at those two and say, do I have sufficient information here to be able to determine what the nature of the relationship is between the filer and this outside entity, to be able to discern whether and to what extent the person has a continuing financial interest in the organization, or if it's some other type of relationship that could present a potential for conflict. It's reading between the parts too to determine that also can give you an indication about whether or not you have sufficient information or whether or not you need to go back and get additional information.
Right. And you can find this discussion on page 46 of the guide if you'd like to look through the sort of standard of scrutiny. We do clarify that we're not auditing these reports.
Right.
We don't have to go behind them and ask our employees for supporting documents. We're not comparing them to their tax returns. But what we do want to make sure is that they understand the reporting requirements, that they understand that they're certifying and attesting to the accuracy of the report. And if we have information on the form that seems to suggest, I just don't think they get it here. Something on the form suggests to me that they don't understand what kind of information we're trying to receive here and we're not getting it. Then we want to go back and make sure that the filer understands what's required and give them an opportunity to remedy any incompleteness. Or alternatively, if we have independent information, the information should be provided there, and we see that it's not there. This may happen in the case of, say, a gift. We know they received the gift. We know that we received the gift because we wrote the opinion about whether they received the gift.
Right.
We can go back and make sure that's reported. Likewise, if you know someone has an outside activity because you engaged in counseling about the outside activity and it's not reported, the income associated with it are not reported, that's a case where you might go back to make sure you have complete information, or to determine that that's no longer a thing, that they've left the position, there was nothing reportable. So this functions as a check on some of our other program areas also.
Well, I think a couple of things too. Spousal employment or spousal interests or something, I think that it's always kind of fair game to follow up with folks on that if you don't see, particularly on an initial report. And I do think there's a different sort of due diligence that you probably are going to need to do with new entrants, because anyone who's filing for the first time, I think we have to make sure that we're comfortable that they are adequately apprised or adequately aware of what the disclosure requirements are for them, so that they're not engaging in, and I don't want to say willful and knowing, but an inadvertent lack of disclosure.
Right.
And with new entrant filers, you may want to do a little bit more querying about things that you would typically see on a report and you don't happen to see on theirs, for example, spousal or dependent child interests.
No, absolutely. I think there's some questions that you probably always want to ask the first time you receive a new entrant report. If you don't see any spousal employment, inquiring whether the employee has a spouse who has assets or employment that ought to be reported, because a lot of employees don't read the instructions. So there's I didn't know I had to report my spouse's stuff. It's a very common error. It's something you probably want to confirm. If you see someone coming in from the outside and they've not disclosed their prior employment, I'd say you're supposed to tell us what you were doing the rest of the year, right? Those kinds of questions you'll learn to ask as you become more comfortable in the review process. But again, that's what we're trying to get to. Does this form as a story make sense? Does it cohere as a whole? Does it reflect an understanding of the reporting requirements? And do we have the information we need to make determinations one way or the other that all of this is either not going to pose a conflict, or there is a potential for conflict and we need to take steps to remedy that problem? So here are the two things we're looking for. This is the most basic way of thinking about the 450. So we need to find out what these people are going to do and whether or not that activity would have an effect on any of the financial holdings that they report on the form. You know, if we had to give a one-sentence explanation for what confidential financial disclosure is for, that's how we would do it. We're looking for any relationship between the financial holdings and the duties of the position. So however it makes sense to get those two pieces of information, your program should be established in order to do so. So now what we'd like to do is walk you through some parts of the form. So actually get into the review process so we can see how this works once we have a form actually hit our desk. And we're going to make some inferences here about the conflict side of things so that we can have some practice thinking about the potential for conflict, as well as thinking about what's actually ought to be reported on the form. So here we have the first page of an OG Form 450, and this report is filed by Jane Q. Filer, and she's a program manager in the Food Safety Division at the Government Department, which is not a real place, but it looks like she works in food safety. So we have some idea about the duties of the position, what she might encounter over the course of the year. And so we're going to do a sort of horseshoes and hand grenades conflicts analysis. We're going to think about whether or not the things on the form fall into the realm of consideration that might fall under someone's duties if they're involved in food safety. I think as a practical matter, this happens to us all the time, where we get a job title and we sort of have a sense of the sector of the economy that someone's work might touch. And so it's okay to do this if you have a single level review process at your agency, to just take a broad view of what the potential for conflict might be and then refine that with the aid of the filer or the filer supervisor or both. So that's kind of what we're going to do here. We're going to assume that basically anything in the food production sort of chain is a potential for conflict that we're going to want to discuss further. We have some information here that's important for us to have. We see it's an annual report. We have the name, position, title, grade, etc. And then we have these boxes down on the lower part of the first page, the review statements. And this is sort of the first kind of audit point on these forms, which is to see if there's coherence between the blocks they have checked on the first page and the things that are attached to the first page. And this is something that you can and maybe ought to train whoever receives these reports to check. So if you have administrative staff who are helping collect these forms, or supervisors, to do a quick check and say, for those blocks where the filer has ticked yes, do we have a corresponding set of entries? And if not, you should just hand it back to the filer and say, go fix it. Because that's what you're going to have to do in any case. So that one sort of audit control function is something that you may be able to outsource to whoever collects these reports to kind of streamline this process so you're not spending a lot of time on the back and forth. And here Jane has told us that she has reportable assets and income. She reports no liabilities, so indicates that there aren't any liabilities to report on the form. She indicates that there are outside positions, agreements and arrangements, and no gifts. So this is, probably a pretty common set of reporting areas for an employee. So let's start at the beginning with part one of the form. So we're going to think about what we expect to see on part one, assets and income. And some of the common entries we're likely to see are securities. So by securities, we mean stock holdings, so owning stock in a company, or mutual funds. And as you may be aware, we're only required to report sector mutual funds on the OG Form 450. Diversified mutual funds don't need to be reported because they are exempt from the conflict of interest statute under 2640, and we'll talk a little bit more about how we distinguish those and how we handle reporting of those two things. We'd also expect to see maybe current or prior non-federal employers. So we know that this person has indicated they have an outside position. We'll be looking for that to see if that's a source of income, if they're receiving income from their outside employment. We would expect to maybe see spouse as non-federal employment if our filer has a spouse. And as Cheryl pointed out earlier, this is a place on a new entrant report certainly that you might want to inquire. Make sure that they understand, if you have a spouse, their assets and income need to be reported, especially if you don't see that and then any outside business or earned income. So if they're consultants or otherwise making money not through an employment type relationship, we may see that here as well.
And as Patrick pointed out, and I think it's a good way to use the cover sheet of the form, is to look at where there are entries or purportedly should be entries. And if you see that there's an outside position, there's something reported on an outside position, you might want to go take a look at that section first.
Right.
I mean, I don't think that you have to feel like you have to review this form in chronological order. So it might be worth your while to go check the outside position section to see what, if any, positions are held, because that will help inform what you think you might expect to see on part one of the form. There's nothing magical about the order you do it in, but I'm thinking of ways that you can help make sense. You can sort of prepare yourself for how am I going to interpret and understand this report to know whether or not I have a sufficient or complete report. And it doesn't have to be I have to go from part one to part two to part three. There might be ways that you're going to want to read this report that are out of chronological order.
Right. So we want to see if we're being told a coherent story here. And we know that if we have an outside position or an outside business, that's an area where we're probably going to get multiple aspects of the story. And if for some reason we don't, we know we're going to have questions, and the sooner we can ask those, the sooner we can get close to the certification standard or to taking action to prevent the potential for conflict. So those are the kinds of things that we would expect to see on part one. So let's take a look at what our filer has actually disclosed for us. So it looks like we have 5 entries here. We have an entry from Walmart. We could assume that this is a security. Maybe, maybe not. If we've not seen this before, we may inquire, or we may look to the outside positions to see if maybe this might be a source of income for the spouse or the filer. That may be a question you want to ask, but we could also probably address this as a security, which is what we're going to do today. We have the iShares U.S. Financial Services ETF, which is a fund of some kind. It looks like it's a fund that specializes in the financial services industry. So we're going to treat this and think about whether this is a sector fund and whether it poses a potential for conflict. So we'll take a look at that. We have Tyson Food. Again, this looks like a security, but if we know that some of our employees sometimes moonlight with companies like this, and it's the first time we've seen it, we may want to inquire as to whether this is an outside position, or to look to the other part of the form to see if this is associated with an outside position. We have the Doe Family Farm. So that doesn't sound like a security. Unless the Doe family is running a very, very large farm. That looks like a small family business. So we're going to have some questions there. And then we have this last entry, the Tyler 401k. So let's just see what the guide can help us with in terms of these entries. So let's take these first two and operate under the assumption that these are securities, Walmart and Tyson Food, and see what it is the guide tells us about the reporting of securities. So if we look to part 3 of the guide, we have a description of stock and the reporting requirements. And basically, if there's a value of more than $1,000 during the reporting period, or at the end of the reporting period, during the reporting period for annual filers, at the end of the reporting period for our new entrant filers, you have to report the stock. And what we need is the name of the company such that we can look it up and figure out what it is they do. It's nice if filers provide us with the ticker symbol because it reduces ambiguity. It makes sure we know exactly what company we're looking for. In this case, our filer hasn't. Doesn't mean we have to go back and get those things, but it would be helpful if they do. They're certainly not prohibited from doing so, but if we just get the name of the company, then that's sufficient to allow us to do some research to find out about the potential for conflict. That's sufficient. So you'll see lots of these in the course of your review of 450s. So those are the reporting requirements for stocks. We also have this fund, this iShares U.S. Financial Services ETF. So it's not a stock. It's a company, but it's an investment company. It's a company of companies. So it's a fund. So our reporting requirements are going to be a little bit different and a little bit complicated compared to those of securities. So we have the entry in the guide for mutual funds and a description of what a mutual fund is. And it's a company that's created to manage and hold a portfolio of securities. So that's basically a company of companies. So we have a potential for conflict because it means that we have an interest in a whole bunch of different companies. And if that were the end of the story, this would be really complicated. Because basically, we have funds that hold hundreds and hundreds of companies, and there's a potential for conflict as a result of all of those. That would be almost unmanageable. And also sort of strange because we have lots of competitors in the pool. So we've made a distinction that I think is very helpful, both for the conflicts analysis, but it also has implications for the reporting, and that's the distinction between sector funds and diversified funds. And the good thing about our definitions of sector versus diversified funds is that we don't have to look at every company within the portfolio of the fund to find out if it is indeed diversified. The piece of information that we look to is the stated investment policy of the fund. So we don't have to go digging through and say, is that 20% or 60% diversified? I'm not sure. We don't need to do the math. We just go to the prospectus and say, what does this fund say that it does? And so in our case of the iShares Financial Services ETF, what we're going to find is they aim to invest in financial services companies. That's a stated investment policy. Their policy is to invest in companies in one sector of the economy. Therefore, we know it is a sector fund. We could also know that it's a sector fund because it invests in companies in one country outside of the United States. So if we go and we see the France fund, well, France is a single country outside of the United States. It's a sector fund. It's reportable, and it also has a potential for consideration under the conflict of interest law. Likewise, if we have funds that focus in the securities or bonds of a single state within the United States. So if we see the Texas Bond Fund, that may be a sector fund that would be reportable.
Okay, Patrick, I have a question for you. So you obviously were very familiar with iShares and ETF, and I'm not as familiar with these types of assets and holdings. So what would you recommend to folks? I mean, if I were to get that form and look at it, I would not necessarily immediately have known that I was looking at a mutual fund and that would be the sort of perspective that I would bring to that holding.
No, absolutely. And I think, the fluency with some of these financial instruments is something that comes with time. And I would go back to our instructions for the technical review, is that you need enough information to figure out what is this thing and is there a potential for conflict. The way I would start is to go to the search engine of my choice and put the information that the filer has given to me into the search block and push go and see what happens. Sometimes you will find that you can locate the fund's website or the fund company's website. Sometimes you'll find that there are a whole bunch of companies, a whole bunch of funds that have kind of the same name, but none of them are exactly the same. And then we have a problem because we don't know what we have. So our responsibility in that case is to go back to the filer and say, all right, this looks like it could be one of these 10 iShares funds. You need to tell me which one it is. If, for example, we had an entry here that just said iShares fund. Well, if we go to iShares website and we look around, we'll find that they offer dozens, maybe hundreds of different funds. So we don't know. We don't have enough information to do a conflicts analysis at that point. So we need to go back and say, which one is it? Is it the food safety fund? Is it the IT sector fund? Is it the growth and income fund? Need to know which one it is. So that's kind of the standard, and that's sort of what I would recommend you start with. And if you don't know, if you're saying, I'm looking, I can't figure out what this thing is, well, we need to go back to the filer and find out. So those would be the two steps that I would use. Likewise with companies. You put in the name of a company, you say, this actually happened to me once. I was working on a nominee report. And I said, I saw this company, and I said, well, I'm just going to go to companyname.com. And so I went to companyname.com, and it was a company, I believe it was in Oregon or Washington State, and they made wood-burning stoves. I said, wood-burning stoves, interesting. I've never seen this company. So, well, the person whose report I'm looking at, there's nothing they could do that would affect the wood-burning stove production industry. And so I sent it up for second-level review, and it came back and said, That holding isn't Wood Burning Stove Company. Search it again. There's an offshore oil and gas logistics company.
Oh, heavens. Big difference there.
They were just a little slow to the URL game.
Oh, dear.
So they did not get the company .com URL. They had the company.co URL or something. So there was ambiguity, and I actually had not done what I needed to do, which was make sure that I knew exactly what this was, and I knew exactly about the potential for conflict of interest. So I would caution you, if there are two companies with the same name and you're not sure which it is, find out, because there's a big difference in the conflicts analysis between wood-burning stoves and offshore oil and gas logistics.
Well, and I think the lesson here is that particularly if you're brand new to the review process, your familiarity with securities and other types of things that you're going to see on these reports is going to have to grow with you.
Right.
So I think that your safest course of action is not even to assume that you think you know what the item is, and your best course of action is to look up everything.
Right.
And your vocabulary will grow, and your sophistication with these types of instruments will grow over time. But I think particularly, and for those folks who only do this episodically as well, the learning curve starts each time you have to engage in this activity. And I can say that as someone who doesn't do too many reviews except for once a year, and I have to re-educate myself every year about things with which I am not familiar. So there's no shame in looking everything up and doing that kind of level of research, although it is time consuming, but I think at the end of the day, that is really what your due diligence is going to require.
No, and the financial services industry is an evolving industry.
Absolutely.
There are new products every year, and there are sophisticated products that used to be available only to very wealthy investors that are made available to retail investors. There's a movement of products and services in that direction all over the place. So you can expect this to change over time. I remember when I started doing this, an exchange-traded fund was an exotic creature. Right now, there are thousands and thousands of them. They're one of the most common assets that we see in the financial disclosure world. But there was a time when they were pretty exotic. They were really unusual. I remember there was an OGE conference. We had someone come explain them to us because they were so new. But 10 years on, yeah, that's a huge feature of people's investment lives. So that's going to continue.
And only one final note before we move on here from this type of asset or holding. We keep talking about how we need to have enough information to do a conflicts analysis, and I think that another material thing for you to understand is we have operational definitions for these types of holdings. So what constitutes a diversified mutual fund or even a mutual fund or a publicly traded security for purposes of your conflicts analysis is defined in 5 CFR Part 2640.
Right.
So OGE has its own sort of understanding and legal definition of these instruments for our purposes, which means for your conflicts purposes. So that's another area where I think you have to become sophisticated in the nomenclature and in the legal definitions that we're operating under when we're doing a conflicts analysis, as opposed to what Wall Street or the Securities and Exchange Commission, their functional definitions of some of these things.
That's an excellent caution, and particularly with funds, because if you go to a fund website, sometimes the prospectus will tell you, it will say it's diversified or not diversified. Our definition of diversified is much broader than Wall Street's definition of diversified. So if you go and see something that says S&P 500 Index Growth Fund, and you look at the prospectus and it says we invest in companies in the S&P 500 aimed at creating growth. That's not a sector within the U.S. economy. That's not a country outside of the United States. It's not one state within the U.S., the bonds thereof. So for our purposes, that's diversified. It very well may say on that same fund's page, non-diversified. OGE doesn't care about Charles Schwab or Vanguard's definition of diversification. We care about our definition of diversification, the one that we give you here in the guide. So just remember that, because otherwise you might drive yourself a little bit crazy saying, just look to our definitions, because they're the ones who matter for this exercise.
Right.
Next we have the Doe family farm. So this looks like a small business, a family business that is a farm. So it's reported. We're not sure whether this constitutes an ownership interest, an employment interest for a member of the filer's family. We don't really know what this is, but we know that we have an interest in a family farm of some kind. So we have some information that we provide you about reporting for small businesses. So filers must report a small business that they operate if the value of the business was more than $1,000 at the end of the reporting period, or if they receive more than $1,000 in income during the reporting period. So again, we go back to that one rule. It's the $1,000. If it's worth more than $1,000, report it. If you got more than $1,000, you have to report it. We'd like the name of the business and the type of the business, unless that information is already readily available to us. Here, we kind of have that. We have the name of it. It's Doe Family Farm. What is it? Sounds like a farm. Unless they're deceiving us, it seems like a farm. So we need, again, to go back to our standard for technical reporting, we need enough information to tell what this thing is and whether there's a potential for conflict there.
And also, we do have an entry in the guide for both family business, farm businesses, as well as passive interests in a farm. So, if you want to look at that section of the guide, you could look at that too. But I think, as a general proposition, the small business disclosure requirements, as articulated here in what Patrick has up on the screen, are gonna do you well or see you well for any type of small business. But it's just kind of as an aside, we do have a discrete couple of entries for farm holdings in the guide as well.
Yes. And we do have a discussion here about how we report the way that a business is incorporated. It's often helpful to find out if something is a C corporation or a sole proprietorship, because that has implications for our conflicts analysis. Whether this thing constitutes a separate legal person in the form of a corporation, or if it's a sole proprietorship where it's our filer just doing something for money. Because when we're looking at some of the other conflict of interest laws, and we discuss this a lot in our outside activities classes, there's a big implication about whether you can make representations on behalf of the business. So if your business is a separate legal person, for example, a corporation, our federal employee cannot represent that business back to the government under 18 U.S.C. sections 203 and 205. However, if it's a sole proprietorship, so this is, Bill doing business, Bill can represent himself back to the government under section 205. So the corporate structure of the business can be important to our analysis. And I'd encourage you to think about that through the outside activities review process. We're not going to go through that whole process today. But where you see that, we have all of the considerations here that we would with an outside activity, the first thing I'd do, go find out if this person has been advised about that outside activity already. Ideally, that's what we'd like to see, is to go into their file and say, you know what, we looked at this. They came to us and said, this is an outside activity I've had. We've provided them advice. We might resend them the advice upon certification of their report. Or we saw it on a new entrant report and we took care of it then. Or they complied with our agency's prior approval requirements. But if this is new, you've never seen this outside activity before, what you really want to do is trigger that process. Make sure that you give a full opinion about the outside activity, because it's going to go beyond simply the potential for 208 conflict of interest. And finally, we have the 401k, which is probably not sufficiently reported here. And you're going to see this a lot.
401ks, 403bs, they're another type of pension system or retirement account that people can sometimes have, individual retirement accounts. Anything where you're basically they're giving you full indication that this thing is an account, but that's it. That's where they think that they can end the disclosure.
Yeah, and the discussion that you want to find in the guide when you look at a 401k is our discussion of defined contribution plans. So when we're talking about 401ks, 403bs, 547 plans, these numbers refer to the portion of the tax code that allows people to hold holdings in these kinds of retirement accounts in some sort of tax deferred status. So that's all it means. It's just the tax status of the account. It doesn't tell us about the potential for conflict. It doesn't tell us what's held inside of it. It just tells us that in some way there's a special tax treatment of the holdings within that account. So the question is, what do we need in order to conduct our conflicts of interest analysis if the tax designation is insufficient? Well, in short, we need to know what is held within it. Mm-hmm. And something must be held within it. There's no such thing as sort of a 401k per se.
Right.
You can't just have a sentence from the tax code. It's a sentence from a tax code that protects something from some kind of taxation. And that something may be a lot of things. It could be diversified mutual funds, in which case we don't need to report them. Mm-hmm. It could be sector mutual funds, in which case we do need to report them, and we do need to conduct a conflicts of analysis upon those sector funds. It could be securities of companies, which would be reportable, and we would need to conduct a conflicts analysis of those securities. It could be cash, in which case it might not be reportable at all. Mm-hmm. But if we don't know, all we have is Tyler 401k, we don't have enough information to determine definitively one way or the other there's no potential for conflict, or there is, and we're going to take steps to remedy it. Mm-hmm. So because that's where we are, we need to go back to the filer, and we need to go back to the filer every time and say, what's in the 401k? Is there anything reportable? And if they come back and they say, oh, I just have this one diversified mutual fund. I have the Vanguard Total Market Index Fund. That's all that's held. Okay, no problem. We can take it off the report, leave 401k, make a note that says diversified mutual funds only. No worries. Likewise, if it's cash. If there are things that are reportable held within the account, those have to go on the form. We conduct our conflicts analysis on those individual assets. This is equally true for the filer and the spouse. Mm-hmm. So if you have a filer whose spouse has non-federal employment and you're seeing that for the first time, I would almost always ask, is there a deferred compensation or a defined contribution plan there somewhere? Mm-hmm. And does it have underlying holdings? Because that's an area of underreporting we see all the time.
And this is one of those instances, too, where because a 401k can hold a variety of different assets, some of which may be reportable and others of which may not, rather than asking the filer to necessarily go through that distinct determination and then maybe get it wrong,
right,
that might be an instance where you go back to the filer and say, can you please just share with me everything that's in it, and then we can decide what, if anything, needs to be on the report itself. Because this is one area where I think the level of sophistication that we expect filers to have about the distinction between a diversified versus a sector fund, and whether or not they report the cash piece of it as opposed to the securities part of it, I think just invites not just confusion, but an awful lot of unnecessary back and forth. And this is a time, too, where I think over-reporting, as long as the employee knows that they would possibly be over-reporting, is no harm, no foul.
No, absolutely. And I think there's some good strategies you can use for the over-reporting issue. So we used to require diversified funds to be reported on the 450. We changed that to save reviewers time in the process, because reviewers told us they were spending a lot of time going back to complete fund names of obviously diversified funds. Mm-hmm. And that's silly. That's not a good use of our time. So we said, they don't need to be reported because they're exempt. So if in your request to employees to file their 450s, you inform them that they don't need to report cash accounts or diversified mutual funds, but if they don't want to mess with the distinction and just put everything on there, they may elect to over-report. Mm-hmm. I think that's sufficient notice not to have to go back to them on after you receive the form to see if they want to redact those things that they needn't have reported in the first place. Mm-hmm. Because I completely empathize with filers who say, I have 7 mutual funds in the 401k. It takes me 6 minutes to report them all on the form.
Right.
Or I could spend half an hour trying to look up the prospectus and figure out if it's diversified or not.
Right.
I don't want to do that. So if they want to put that work on us, I think that's fair. Mm-hmm. So then once we have information about what these things are, once we've completed the technical portion of our review, we need to do a conflicts analysis. Mm-hmm. Again, we remember our person worked in food safety. Walmart sells food.
Yes.
A lot of it.
Yes.
Maybe
they're
most
one of the biggest grocers in the world, I think.
Yeah. I'm not sure what our filer does, but I think this is a question that I would have for our filer and or the filer supervisor. Is Walmart in the scope or in the range of companies that might pose a potential for conflict for this person? And I'd want to answer that question before I certified this report. Either in the affirmative, that it's a potential problem and we've taken steps to remedy it, or in the negative, Walmart doesn't come before this person, no way, no how. Fine, we can move on. Financial services seems unlikely to find a nexus between the financial services and the food safety business. Unless we had some extra information to suggest there's a potential problem, we can probably say, it's good this was reported this way. There's not a potential for conflict here. We can move on. Tyson Food?
I think that was probably squarely fall within the ambit of food safety.
I think it's, as a food producer, I think there's a strong possibility that there's a conflict here. So we either need to find out that an exemption applies, think about divestiture, or have a long chat with the filer and the supervisor to make sure that they can keep the filer out of any matters affecting Tyson, or to determine that really this isn't an area in this person's purview. But I'd push on that pretty hard, I think.
Well, and the thing here too is like when you are going back to the filer and you are trying to come up with remediation for anything that you see that is either clearly going to be a conflict or could potentially be a conflict. I mean, we have to note here, and we've kind of not recognized that there are no dollar amounts that they have to disclose on the report. But we also know that for the exemptions for publicly traded securities in particular to apply, that there are de minimis thresholds that apply to any securities holdings with respect to 208 conflicts of interest. So knowing what the dollar values for these entries is going to be a material consideration in how you're going to go about remediating these. So that will be part of the conversation when you go back to the filer, is not only discussing whether and to what extent their duty portfolio is going to overlap with or perhaps have an effect on these entities, but it's also to ascertain what is the dollar value of their interest in this, and then that can help inform the course of action you take. No,
absolutely. So that's going to be our first step, is to find out if an exemption applies when we see a potential for conflict. So we also have this entry for the Doe family farm. We don't know.
Right.
I don't know what the Doe family farm produces in the way of foodstuffs, if they even produce food for humans, right? They could produce feed or other kinds of agricultural products. We just don't know. So we'd have some more questions. And we probably don't have enough information about what this represents, whether this is income or ownership or an outside position. So we're going to look to reconcile that on another part of the form. And then, as we just discussed, the 401k. We're going to have to go back and find out what the underlying holdings are, whether they're reportable, and then conduct a conflicts analysis on those underlying holdings.
Okay.
So as you recall, we did not have any liabilities reported, or at least our filer didn't tell us we had any liabilities reported. So we're going to move on to Part 3. And in Part 3, we're looking for outside employment type relationships. So the things that we're likely to see, this part only applies to the filer. We would expect to see on a new entrant maybe prior non-federal employment, outside employment including consulting or businesses that they own. So if they have an outside business or outside employment that's concurrent with federal service, we'd expect to see that here. And then certain kinds of outside activities. So let's see what we have. So we have the instructions up here. We went over those last session, and in the reportable information section, indeed, we do have a position with the Doe family farm. So our filer has understood, it looks like, the outside positions reporting requirements, and they've indicated to us that they are the treasurer of the Doe family farm.
So we know that they hold a position, and they hold a fiduciary position with the farm. So that's going to make our analysis a little bit more complicated than if it were just a passive investment interest in the farm itself without any actual participation as an officer of the farm.
Right. So for 208 purposes, for our criminal conflict of interest statute, we can fairly well assume that the interests of the Doe family farm are going to be fully imputed to our filer. Right. So it's as if the filer is the farm. Any government matter that affects the financial interest of the farm is going to be a potential problem for us. Something else that stands out to me is it's a treasurer position. It seems that there's a danger that the employee may be asked to make representations to the government on behalf of the firm. For example, filing taxes, requesting loans or subsidies, requesting insurance, those kinds of things. It's a big red flag. That's kind of worrying for us as ethics officials. And I think this is the case where you run to the filing cabinet and say, do we have an outside activities opinion that we have given to this filer about this position? And if we don't, we need to initiate that process pronto. Because it's not just that there's a potential for a 208 conflict of interest here, but maybe a representational issue under Section 203 or 205 of Title 18. We may have misuse concerns that we want to counsel them on. We may even have supplementation of salary considerations. There could be a whole host of problems here. And we just want to make sure that that process, if it's not already taken place, is initiated as soon as possible.
And I think that's exactly it. What we have here is that you had the Doe family farm on part one, so you kind of had some sensibility that there was some aspect to this that required it to be reported on part one. But what part three does for you is to say, we need a much bigger, more complete picture of the financial relationship between the filer and this small business now. And now we have to call into question, are we talking about earned income?
Right.
Or are we only talking about investment income? And are we talking about things that are over and above, like maybe Doe Family Farm has other investment interests that other than just the cattle or the land or whatever it is that's held for the production of income. There might be some liabilities questions that come up. For example, maybe the farm has given personal loans to him, that should be reportable in the form. So it gives you a much more complex idea of the kind of information you really do need to get your hands on and get your head around in order to be able to adequately address the whole portfolio, as it were, of ethics issues that might be
absolutely
at play here.
And sort of going back to our prime directive about how much information we need, we know that when we do an outside activities analysis, we receive a lot more information. We request a lot more information from employees than the 450 would ever provide us.
Exactly.
We want to know about whether you get travel payments from them. We want to know when you get paid, how much you get paid, how your pay is set. We have all sorts of questions. Do you talk to the government? Do you have any business with the government? Does your company receive benefits from the government? None of that gets captured on the 450, but all of it is necessary for us to ensure compliance with the applicable laws and regulations. So this is just sort of a trigger to start that process.
Yeah, Doe Family Farm might be a prohibited source for the agency, and if it is, then you've got a whole host of gift issues potentially that come into play. So yeah, it gets very complicated very quickly.
Yeah, so that's what we see here. Filers should report any position held with the business during the reporting period, and we have that available to us here, and that should start our, if we haven't already done it, the outside activities counseling process. So from a conflicts perspective, it seems like, yeah, maybe there's a lot of possibility in a lot of different ways. Is there a potential for a 208 conflict? If Doe Family Farm is engaged in the business of food production, and that's something that our filer works on, certainly that's a possibility. But as we mentioned before, there could be representational considerations. There could be concerns about seeking benefits from the government. There are some additional things we're going to need to think about, and we should do that in the context of a full outside activities analysis. Finally, we have part 4. So these are agreements or arrangements. So these are ongoing agreements of the filers. So agreements for outside employment. So if they have an arrangement concerning future employment, we would expect to see that here. Ongoing retirement and other benefits from private employers, or leaves of absence from financial institutions or from educational institutions. So we do have an agreement indicated here. Our filer tells us that she will continue to participate in the Doe Family Farm Health Plan. So we have a further indicator that this is something other than just a mere investment type interest or just a fee-for-service situation. It sounds like the Doe Family Farm is something more like an outside employment relationship, so we can be further assured that what we're looking at here is really an outside position that needs to go through the outside activities counseling process, and we need to consider all of these, including the potential for conflict that may arise from the health plan of the family farm. Things you might also see here, defined benefit pension plans. So these are our traditional pensions. So if someone has a former outside employer, these are less common these days, but they have a defined benefit plan from a former employer where the former employer has made a promise to pay them some benefit certain at some time in the future. So for example, upon reaching the age of 55, I'm going to get $1,000 a month. If you have folks that have those kinds of arrangements, we'd expect those to appear on Part 4. Likewise, concurrent outside employment arrangements. So if we have an agreement for future employment, we'd expect to see that here if someone's transitioning out of government, or if they're looking for concurrent employment and they have an arrangement. Those kinds of things we'd expect to see here. And again, we can reconcile this with other parts of the form.
Mm-hmm. Well, one thing I wanted to sort of highlight too is that with Parts 3 and Part 4, with the outside activities, outside position provisions and the agreements and arrangements, it's only the filer's interests in these types of things that are required to be reported in those parts of the form. But if you remember back to Part 1, we didn't have an indication one way or the other with respect to the 401k, with respect to the Doe family farm, whether or not that was the filer's holding or whether or not that was the spouse's holding. Now, for purposes of Part 1, some things it's not going to matter whether there's a distinction, whether you can distinguish immediately on its face whether it's the spouse's or the filer's. Things like securities, they're going to be treated the same whether they're the spouse's or the filer's. But where that designation can really help you out, and you might want to encourage your filers to designate, is when you have sources of non-investment income, things that are like earned income sources, to make sure that they designate, whether it's the spouses or the filers, because it can save you some unnecessary following up. If it's clearly the spouses, then you don't need to see anything in the outside positions, and you don't need to see anything in the agreements and arrangements because you don't report those things for the spouse. Whereas if it's clear that it's the filers and you don't see things that you think should be in either Part 3 or Part 4, you know immediately to go back and follow up on those.
No, absolutely. And I think that's another case of us needing to use that rule. Mm-hmm. Do we have enough information to figure out what this is and what the real potential for conflict is or isn't? And if you don't know if there's ambiguity that's important to your analysis that you've not figured out, well, you need more information.
Right.
So again, in the guide, it discusses with us what we expect to see on Part 4. So the last and perhaps most important step is where we find the potential for conflict, we really need to resolve those conflicts of interest. Mm-hmm. The first thing we want to do is look to see if there's an exemption. If we're looking at a potential conflict under our financial conflict of interest law, 18 U.S.C. Section 208, we should look to 5 CFR 2640 to see if an exemption will apply. Mm-hmm. And oftentimes this is going to be a case where you need more information. So if you're going to use the exemption for sector mutual funds, you're going to need to go back to your filer and find out what the value of their funds, what those values are. Mm-hmm. If you're going to use the securities exemption, you're going to have to go back and ask them, how much is this security worth? Sort of a balancing test, collecting the information on the 450, whether or not we should have people indicate the value. Well, in the case that there's no potential for conflict, we don't need the value.
Right.
When there is a potential for conflict, we're going to have a conversation about this anyway. Mm-hmm. So part of that conversation is going to be about valuation. So the first step, look to see if there's an exemption, and we have some classes on the IEG about the commonly used exemptions if you're not familiar with them. If no exemption applies, we need to look for something else. So that may be recusal, which just means keeping them out of matters that would potentially affect their financial holdings. That's the default remedy. If you see the potential for conflict and you're not sure, you don't know if an exemption applies, you don't know if you're going to need another remedy, this is the thing to advise employees of as soon as possible. Mm-hmm. So stop what you're doing. Don't work on anything affecting Tyson. Until we get this sorted out, just stop. Mm-hmm. So if that's our situation with our filer, we saw this report, that would be our first course of action. And then we say, well, is that practicable? Is that going to allow our filer to fully conduct the duties of her position? And if the answer is the recusal is not going to work, it's keeping her out of work that she really needs to be doing for us, we can look for something else. And that may be divestiture. We ask our filer to sell Tyson food stock. You say, you know what, you need to get rid of this so you can do your job. We can do that. Subpart F of the standards discusses when and under what circumstances we can do that, but we definitely can suggest that you need to divest of this because otherwise you can't do your job. That's probably the second most common remedy. I'll go to the last one, resignation. If the Doe family farm treasurer position poses a conflict of interest that basically prevents our filer from doing her job, we can say, look, you got to pick one of these jobs. If you want to keep doing this job in food safety at government agency, you have to resign from your treasurer position at Doe Family Farm. If that's appropriate, that's a remedy that's available to us, and sometimes it is. Oftentimes, the conflicts with outside activities can be managed through some combination of recusal and counseling, but if they can't, resignation is a possibility. Less common are 208 waivers if we have a financial interest that is of a relatively small valuation, and we don't think that the holding of that interest would affect the integrity of someone's service. We may contemplate a 208 waiver. Very uncommon compared to the other remedies, and if you're contemplating that, you're directed to consult with OG wherever practicable, which I think means if you're within a few hundred yards of a telephone, which I think most of us are at all times now. So you really should reach out to OG if you're contemplating a 208B1 waiver. And again, not a very common remedy, especially in the 450 filer. And the last one is where we have considerations where it's a mere appearance issue, meaning there's no criminal conflict of interest situation. It's just an appearance consideration, for example, with a former employer with no ongoing financial relationships or agreements and arrangements. We may be able to do an authorization under Subpart E of the standards to remedy that appearance consideration. So those are our remedies. We have some classes on remedies and exemptions in the IAG store if you're not familiar with them. And again, I think these are the conversations you're going to have after your review, where you've identified potential for conflict. And it's going to be a team effort to decide which is appropriate.
Right.
You're going to have to talk to the supervisor to see whether recusal is going to work. You're going to have to talk to maybe your DEO or ADEO to see if there's any comfort or desire to contemplate a waiver, or if divestiture is more appropriate. Just one last thing to leave you with, it's an area of frustration sometimes. If you're asking someone to divest and they're going to incur tax consequences, there is a possibility to defer those through a certificate of divestiture. So if you're asking someone to divest a large holding where they're going to take a big tax hit, call your desk officer at OGE. We can walk you through the process for applying for the certificate of divestiture so that your employee does not incur tax consequences for a directed divestiture. But the thing to remember about this is you have to get that certificate before the divestiture takes place.
Yes.
It's a tax law thing. You have to have it when you make the sale. So if you have a situation where divestiture is necessary, reach out to us as soon as possible so we can help you start that process. So that's it for today. That's it for our series on the confidential financial disclosure system. This is the general review process. This isn't the sum total of guidance available to you. We'd encourage you to use the tools in the Institute for Ethics and Government. If there are any of these areas you're not familiar with, you want to learn more about the conflict of interest laws, take a look at the conflicts of interest classes. And we'll probably be doing some more activities, some more broadcasts early in the new year to help you and intermediate reviewers.
Yeah, we look forward to seeing you. We were hoping in January to do a more fulsome, full-blown exercise with you to give you an opportunity to actually practice. We'll give you an example and give you an opportunity to practice your review skills, which we'll then debrief through a broadcast. But until then, we hope everyone has a lovely holiday, and we'll see you after the new year.
Yes, see you in the new year.